We're going to finish section 13 today, and then next week, our last week, we have sections 14 and 15 to do before we do our exam. And our exam is, I think it's May 14th at 6 p.m., right? Okay, so everyone will be there and on time and ready to take their final exam. And as I said before, you should look at some of the old exams that are either on reserve at the library desk or online, so you have a feel for what you're looking at. Won't be a lot of surprises. Take a hard look at it and hopefully take a few moments to outline it and give me a really good answer so that I can look at it and see that you have a mastery of the material, and that way I can give everyone A's, which I know you would like to get. So meet me halfway. Let's talk a little more about these nuisances, injunctions, and the like. And again, as I said before, this is an area that is litigated quite often. And whether it's neighbor versus neighbor or neighbor versus business, and obviously that happens a lot as well, is that you've got neighbors upset with various things going on. I know a number of you first year had the issue with that happens up here with these real estate developments that occur very close to farms that had existed for centuries. But as people come up from the city, and while we think we like the rural character of the area, we end up not liking it all that much. I remember two things. I was my brother lives in Maine. One of the first times up there, he went outside and I said, "What the hell is that smell?" And he lived in Turner at the time, which is just outside of Lewis, not just outside, that's sort of Maine, just outside. It's about 50 minutes. It's the egg farms up there. The chickens smell horrible, and so do what's left from the eggs. We got out of the airport in Savannah and got out to hail a cab, and the whole place stunk like you wouldn't believe. I mean, seriously, to the point where us rude northerners like get out and say, "What the hell is that stink?" And either the cab driver or the guy who was getting us the cab said, "That's the smell of money, boy." The paper plants in Savannah are so noxious, in my opinion, that it just becomes part of what you get used to, I guess. And obviously, if people are working, working's important, but I've told you before, I think I told you in evidence related to a story, is that when I was little, we used to have the Walter Baker chocolate factory, well, not near us, a few miles away, but you could smell chocolate most days. I happen to like the smell of chocolate, but I imagine most people wouldn't. Now I've got a coffee roaster near us, and you get up in the morning and you can smell coffee. I mean, and I'm still a couple miles away from where that is. I drive past it, and obviously the smell gets stronger. Are those things all capable of some neighbor saying, I don't like it? Because I've got worse examples, but I'm thinking of those right now. That are those all things people are capable of going in and saying, well, this is either a nuisance or a trespass, and we'll talk a little more about that again, such that they might have rights to go in and join the operation of those places that people work in, that make a living, and that contribute in some ways to the community? Go ahead.
Well, isn't part of it when you move in, if that smell has already been there, they go, you bought in, baby, that's it.
Is that it? Because I had that case too. I had that case when I was in Boston. Person that lived, seriously, when I was little, we lived in Dorchester, and this person moved in probably 8 houses away from where we used to live. Immediately behind it, where she bought, was this one of the largest auto body places ever, I would imagine, in the city, to the point where they had all the city work for respect to police cars and you name it. So it was a huge auto body company, huge. I mean, it took up maybe half a city block, but there were houses all around the outside of the auto body in the area. And she came in to the office and she says, it smells like paint. Kids can't go into the yard sometimes because it smells so much like paint. And that place was there when I was little, so we're talking, it had existed before she moved in, probably 30 years. And she says, I want to do something about it. I want to stop it. Can she? She moved in with it there. And you couldn't miss it. Sometimes people move in and say, I didn't know. I had one down in Brockton. She bought near the school. She wanted to live near the school, right? She said, that's nice, the kids can walk across the street to the school. School buses in the morning, school buses in the afternoon, leave the buses running, and now we've got diesel fume entering the homes. She wants to stop that. You bought across from the school, you know the kids and the buses are there. Frankly, you thought it was an advantage. As it turns out, like sometimes the cow smells near my house, it's not all that much of an advantage. Are those all situations where people are capable of it? So tell me what you would tell this person that bought in my old neighborhood who comes in, because partly I was thinking of telling her just what you said is, well, what the hell were you thinking? There's cars in various state of disrepair strewn throughout that lot. And clearly it is not a state-of-the-art painting facility, never was. You could smell paint. So do you just tell her goodbye? Does she have a recourse?
I know like courts in inequity in some of the other cases, they look at like, do they, for example, if they were selling something, like do they service cars in that case in the area, you know, or do they ship cars from some other state, and they'd probably say too bad if they were giving them, if they were helping people in the community, they look at that, and how much if the community's changed, is there other car.
But is that the way that works? It's how much has it changed, or if they're making a service? Because, you know, even now, I drive home, I drive through Lawrence, there are houses, just like Dorchester, just like the city, there are houses next to businesses, and one of the places I have my car, the auto body work done, there are people living very close to it that I can't imagine don't smell paint and don't have similar problems. Is it that, well, they were there first, or there's a social utility to it, or what happened to the last case, and what about Boomer, where they say, you know, listen, what you do on your own land is one thing, but when you create a nuisance to the point, or trespass to the point that it affects someone else's land, now this is where the law steps in. So
It's got to get to the point of a public nuisance too,
it could or does have to.
for a better chance of winning, because caveat emptor is alive and well in property.
Okay, so caveat emptor says you should have known a little better. Well, we do have cases which say you can move to the nuisance and still complain about it, right?
Yes.
So tell me what your advice is to any of these people.
I think you've got to get the history of it, because I think down in Woburn there's a gelatin plant that people complain about.
Road gets slick. Road used to get slick on 93 sometimes.
But
When
it smelled great.
Huh?
It smelled great. It's better than the tannery.
I know, but much better than the tannery. But you and I may like the smell of gelatin, some people don't, but go ahead.
But I think that when people complain for a while, then it gets fixed for a while and it comes back. And so then you have to look at it. So if you learn the history of it and you learn that there's something that the company can do to address the problem, like in the lagoon case, and they're not, I think you've got a pretty good likelihood.
Well, we have, by the way, the lagoon case in North Danville. Again, where I drive home, and it'll probably be in, well, it could be soon now. When I drive up the street, there are times where, near where the sewage treatment plant is, that you go up that street, you smell it like you wouldn't believe. And if you lived, I mean, there are lots of houses right around it. If you lived there, you'd say, you guys got to do something better than this, because I smell shit a month of the year at least. And when it's hot and the wind's blowing right, that's not chocolate, that's not gelatin, it's not.
They didn't have the Salem, I don't know if the coal had it, but the Salem.
The coal plant?
Yeah, next to the power plant was a water company, and you could still see there's like steps going up to nothing, so they must have bought out the few houses that were right next to it. There's like 4 houses where you just see, you know, you can still see the cement and stuff, but the houses are gone, so.
So do people have recourse? I mean, okay, so we look at the history, we know that they can do something. By the way, the auto body, I mean, there are modern things they can do with these plants that would prohibit some of the emissions. Oh, and some of it is just simply comply with the law. If you're going to be painting, you've got to close the doors, you've got to make sure you've got scrubbers working on the air purification. But all of this is expensive, and all of this may well slow down production. And so the companies are loath to do it because they're in the business of making money. Do your clients have rights? And what are they? Are these trespasses a nuisance? Like the paint that enters her land. And she could prove it, say, because she's taken particles and had them tested, and it's auto body paint. There's no doubt. I mean, if your nose wasn't sufficient, she's got evidence that the paint is entering her land. And she doesn't want her little kids in the yard, which seems eminently reasonable if they're ingesting paint fumes. Not intentionally, right? So what? And sound. Could do they have rights? That's what I want to know. What's your advice to them? Live with it. Why did you buy there? Move. Let's get our facts and go to court. I'm wondering what your advice to them is.
Sue for damages, possibly sue to enjoin them. It's going to be difficult to enjoin them, though.
So you want to sue for damages as well as an injunction, damages for past violations, injunction against future harm, or permanent damages of some sort because of it's lessened the value of your property. But so I just want to know, so we're going to court or we're not? Can you come to the nuisance and still sue? First of all, let's take that.
Yeah.
You can,
Yeah.
right? It's not an absolute bar to come to the nuisance and still seek some help. That's the Del Webb case, which I think you should have looked at in one of the other classes by now. But even in Boomer versus Atlantic Cement, the plant was there, and the plant was there well before the people were there, right? I mean, go look at Charlestown where the train station is. Boston Sand and Gravel was there. That's what probably helped create the city. And we didn't want them too far out because there's a social utility to what they do. But then at some point, the city is all around them and people don't want their homes interfered with in that way. So would you file suit? Can you file suit? Would you file suit? What is it a nuisance or is it a trespass? Pick any of them you want. Nuisance. Because it interferes with the use and enjoyment of your land.
And it's not trespassery, right?
And it's non-trespassery, but is it non or not? Because if that smell enters my land, isn't that?
No, the scent itself would be non-trespassery. If it was actual paint, maybe it could be trespassing.
So the smell isn't?
No,
Why not?
it's not a person.
Oh, it's got, again, we're back to Admiral's point, doesn't have to be a person to be a trespass?
No, but it does need to be a thing in a sense, although it can be
there's
qualified as a
bodies in
thing,
the
it's
air.
not a tangible thing.
But smell isn't tangible?
Can you touch it?
Yeah, you could, I mean, if there's
You can touch
particles
a
of
smell.
paint, if there's particles of paint in the air, I guess.
You can
could
touch
argue
a
it.
smell.
You could argue that there's particles.
Do you have to touch it?
No.
You don't?
Sound could be.
Because someone told me, I was going to say, well, someone, Mark, said that noise could be, but noise could be a trespass.
Yeah.
It certainly could be a nuisance. No, Matt looks dubious of that.
I think it could be a nuisance, I don't think it could be a trespass.
I think they call it a trespass in that decoy, I don't know, I just remember the decoy.
What's your definition of trespass, again?
Unlawful entry.
Unlawful entry onto the land of another without permission, right?
Smell entered the land.
But isn't the word unlawful? Let's think about that, and that's the kind. Look at the word unlawful and then think of it as a nuisance. I would characterize this as a nuisance as opposed to a trespass, just because of the word unlawful, because where does that come from?
You don't want it there.
Yeah, but then for me, I look at it and say, okay, it's more of a nuisance than it is a trespass.
It's interfering with your enjoyment of the land by a non-trespassery means like a vapor or a gas or a light.
Well, we think it does.
Yeah.
And frankly, this is part of the problem, is you probably likely in the real world will plead both. Because there may be portions of the activities that do, in fact, some may be trespassery, some may not be. Do all of these examples, do they have the right to go to court, sue for past damages, and then seek injunctive relief against the future violations, whether it's the noxious odors coming from the sewage treatment plant or the paint smells, or whatever?
but they look at, a lot of times they look at, like, you have to look at what the company you're talking with. A lot of times they look at, like, how long has it been there, is it a tradition of the city, you know, is it, well, in the cement case, they say, well, the whole town will shut down if we shut down this plant, you know what I mean? So they kind of look at it in equity and say, all right, what's the best for this area, you know?
Well, wait a minute, let's take a look at Boomer versus Atlantic Cement, because it is a good case and it's an older case. And here it's, the neighboring landowners sustained injury to the property from dirt, smoke, vibration from the cement plant. Defendant's cement plant was valued in excess of 40. The investment was over 45 million. 300 people were employed by that plant. And the neighbors are arguing that it's a nuisance. And I believe correctly they're arguing it's a nuisance because the court says a nuisance has been found after trial. Temporary damages have been allowed, but an injunction has been denied. And then I'm looking at page 315. It says, the rule in New York has been that such a nuisance will be enjoined, although marked disparity be shown in economic consequence between the effect of the injunction and the effect of the nuisance. Where there's a nuisance has been found, and where there's been any substantial damage shown by the party complaining, an injunction will be granted. It sounds like they're entitled to not just the damages for the past violations. And what is the difference between the temporary and permanent aspect of that? Why is that terminology used? Go ahead.
They would pay them a bunch of money if it's permanent, and it would stay with the, you know, you want it on the property.
So what's temporary? Just let's define.
Temporary, you just give them money for what has already happened. You know how long the nuisance is going to occur. You would come up with damages for how long it's going to be. If it's permanent, you would have to either buy them out or, you know what I mean?
Well, what makes something permanent and what makes something temporary?
Well, I mean, if it's not going to last indefinitely.
So if something can be,
the plant's going to shut down in 1 month.
if something can be fixed, it's temporary, and if
Right.
something can't be fixed, it's permanent. Right? Okay, temporary is fixable. Temporary, somehow we can alleviate it in some fashion. So something that's temporary, we should more look at injunctions and relief for the earlier violations. Permanent, we have to decide it may not be fixable. And now we've got some harsher decisions with respect to what to do with respect to the injunction, or potentially award permanent damages, in essence, as what they call inverse condemnation. We award damages against the defendant, but allow it to exist, and that permanent award then, in essence, affixes to the land, so future landowners wouldn't have any right to pursue relief. But in Boomer, they're talking about, regardless of the economic disparity here, the ability to grant an injunction, either delay it. It says one alternative is to grant the injunction but postpone its effect to a specified future date to give opportunity for technical advances.
Which they said just wasn't going to happen in the time frame that they were saying.
Right? It's not likely to be. Again, some of these, especially these older utilities, are not likely to be able to come into compliance with modern standards or to not interfere with their neighbors in some way, either within a reasonable time or perhaps economically ever.
This one could have had major precedent problems. What happens if they gave that, or they enjoined it? Now you're going to shut down every cement factory in the country because everyone's going to bring into court and try to use this as this case to bring in that it's a nuisance, and then there's no more foundations
I'm more
built.
concerned with
But-
like the town and
But,
not the town.
but it is a nuisance, isn't it? I mean, what if you guys live near this? Dirt, smoke, and vibration. Well, what if you live near a quarry or the sand and gravel where they are blasting on a regular basis or have one of those machines that takes the big rocks and makes them little rocks, and you've got to listen to that?
Well, you're underneath those big highways anyway. You're probably not.
No, yeah, well, go try and buy a condo in Charlestown these days, right? You're going to find that we haven't heard the last of that problem, you know. So So it is a nuisance, isn't it?
I would argue, yeah.
Dirt, smoke, vibration emanating from defendant's cement plant. You really want to be next to that? Or we just say, well, listen, we need, and this is part of the problem, right? We need cement. We need airports. Or how would you like to live next to the airport? How many of you take it?
House without a foundation.
Well, but you say that, and I heard that, but why can't they build a cement plant just simply further away? Buy more land, buy enough that you're not going to interfere
Buy a
with...
house further away. You
Huh?
have that cement plant with it. Why don't you buy a house further?
Well, but so is that what it is? The cement, who's there first gets the rights, because the law isn't consistent with that, right? We see it in the farming situations up here, where people move into the farms and say, holy crap, I don't want these smells. Or they do move next to bakeries or cement plants. Or, listen, everyone who bought near that sewage treatment plant in North Andover likely paid less for their house than those further away, right? Because it smells for a period of time. But once you're there, they still don't want to be smelling, and no one wants to smell that for...
Get used to it.
Huh?
Get used to it.
No,
I don't know whether you get used to it. Doesn't appear you do. But so how do we balance that? How do you, because it is a nuisance, right? But by your legal definition, you have to say a lot of these things are nuisances, right? Whether it's the sewage treatment plant, whether it's the cement plant, whether it's a quarry of some sort, whether it's a small airport, right? I mean, all of these potentially interfere with your use and enjoyment. So you still have a right to go to court, but we do have to balance some of the utility of what they're doing, and equity can fashion a remedy of some sort. What do they do in Boomer?
They love making cement.
For how long, though?
I think they kind of scream at the legislature to make a change, not the court.
Listen, the bottom of 317, I want you to see the point here. The damage base here suggested is consistent with general rule in those nuisance cases where damages are allowed. Where a nuisance is of such a permanent and unabatable character, that's what makes it permanent, it's unabatable, then a single recovery can be had, including the whole damage, past and future, resulting therefrom, there can be but one recovery. It is said that permanent damages are allowed where the loss recoverable would obviously be small as compared with the cost of the removal of the nuisance. And this is where we start to balance the question about permanent award of damages as opposed to shutting down the nuisance, because the nuisance has, as Jim points out, the social utility. You're going to have foundations. You know, frankly, we're going to have Mark mentioned the coal plant in Salem. Take your various wind fields now with respect to the windmills, right? If you live near those, they're noisy. And it's not just a view situation. They make a fair amount of noise that didn't exist possibly before, and they are ugly. I don't think you have much of a basis to say they're ugly, I want them out. You do have an argument that the noise could potentially involve a nuisance. But we need electricity. Salem needs that, and I think they finally have done something about the plant in Salem. Because the other part of it is the smoke, it is the dirt that flows from those things as well. And by the way, same type of thing in our town. We need some way to treat sewerage. So it's got to go somewhere.
There's a big battle in the Cape too, because we bought these homes for views, and now you got these things in the ocean.
Very difficult to win a view case. That's why oftentimes you're going to have to make a different argument legally, because no one really, the law doesn't necessarily care about your view. What they do care about is to what extent it might be a nuisance or a trespass or something else. Although what oftentimes motivates a lot of these types of fights are something other than what you end up bringing forward, simply because it may not be legally sustainable. Although if you had a beautiful view and now all of a sudden you're looking at 100 or 1,000 windmills out there, that may be bothersome. I'm not so sure you ever really cared about the view of the cement plant here. If they award permanent damages in Boomer, one argument is, if you're going to do that, then what you've done is you've allowed a private party to, in essence, use inverse condemnation. In essence, you're condemning their property, or at least a portion of it, the use of it, for a private party. That doesn't seem quite fair either, does it? So we get a permanent award of damages, but you're going to have to live with this situation. Is part of it because, well, it was there first,
Benefits the town.
and there's a benefit to it. And that's the balancing that they do here?
And you got paid damages.
And you got paid damages, which should reflect the diminution in value of your land, and if you don't like it, then move. But what happened to the last case where we looked at least in Mass, that, you know, the principle that as I laid it out to you, a man's home is his castle, because now this says, well, there may be situations where the social utility of whatever the operation is of such importance that the nuisance can't truly be alleviated without shutting it down, and we do have to balance the need for whatever it is. I mean, I don't think anyone would choose to live next to an airport. How many of you have used Manchester Airport within the last few years? Did you see the change in that area over the neighborhoods that surrounded it over the last 5 years? You could see all these little houses, and now many of them are gone, and there's these huge walls up. But we gotta have more. We gotta have airports. We have to have travel, and so you can sue, but the court could balance. So you still have the rights to file suit for nuisance, but you may not have an ability to enjoin it. Could I still get an injunction in the right situation, even though there is some?
Yeah.
Yeah.
They did that beef case, I think it was like in San
Yeah,
Antonio, they had
case,
a
too.
slaughterhouse, and they made that move, because they said, look, the area is not, you know, it's more residential.
Becoming more residential, yeah.
So we look at the character of the neighborhood, the character of the activity.
If it's fixable, like that lagoon case, they just had to put the boats back out to scum the water.
Well, I want to talk about. Is that the next one? It is the next one. We can go to that. Pate versus City of Martin. Just if you notice, though, before we leave Boomer, the dissent. Actually, I think it's actually still the majority. One of the concurring opinions. I would enjoin the defendant cement company from continuing the discharge of dust particles upon its neighbor's property unless within 18 months the cement company abated this nuisance. Footnote 7. And that's not unusual either, is to give them some time to try and comply. That way either they can choose to try and figure out how to comply within 18 months, or they can deal with the consequences of the injunction. And sometimes the courts will deal with it in that way to sort of give them some time to come into compliance, or to at least obtain the newer technology that could help. Certainly there's some parts of this nuisance that they may never get rid of, but there are ways in which it could be lessened, and giving them time to comply is another way of trying to work the injunction to benefit the plaintiffs as well. Let's take a look at Pate versus City of Martin, because this is the sewage treatment plant. And as you might guess, sewage treatment plants pose a huge problem in this issue with respect to nuisance and the like, because the stuff, at some point, it's going to smell. What they wanted done in our town is we had various lagoons, and people living close by wanted them covered. They wanted cement covered, and the technology was such that if they had been completely covered, there would be ways in which the chemical process could still be encouraged, but the smells would be significantly reduced. The cost covering the holding bins was somewhere, and this was a number of years ago, somewhere north of $10 million. We said we don't want to pay we can't afford to pay $10 million for a problem that exists 2 to 3 weeks a year. The neighbor said, well, that's fine, but 2 to 3 weeks a year, our houses are virtually uninhabitable. We see Pate versus City of Martin, they fashion a reasonable alternative to it. And by the way, the next time you complain about your job, you remember this little guy in the motorboat and think about his job and be thankful that you're not having to do that. But could the court force the, and it's a regional authority, but could they force them to actually cover the sewage treatment holding areas as a means of reducing or eliminating the nuisance?
The homeowners?
No, the homeowners seek to have the town do it. It's gonna cost $10 million, the town's saying we can't afford it, that's just too expensive for a relatively modest nuisance that really only exists in the particularly hot months when the wind is blowing in the right way. So, is it a nuisance, first of all, the smell? It is. So we do have another nuisance. We can seek damages and we can seek injunctive relief. What's your injunction say? Because eliminate the smell is probably not sufficient to be able to enforce that order at a later point.
Use and enjoyment of property. You're affecting my use and enjoyment of property, can't go outside.
No, that's your argument. What does your order say? What order are you seeking from the court?
I guess you could probably look to see what system the cover has been developed and what regulations have approved it, and then make the order in order to comply with these higher regulations that approve a better system.
So does your order at the end of the day say cover them?
Yeah.
Because cover them is the technology that's available.
Yeah.
And studies show covering it reduces the odors, noxious odors, to by 98%, 95%, whatever it is.
I'm sure some wealthy communities have covered systems. So
I bet a lot of them do, especially if depending on how hard the neighbors fight. But in this case, they've come up with a relatively simple way of eliminating the nuisance, or not eliminating it, but significantly reducing it. The court looks at alternatives like that as well to try and figure out what's the most reasonable way.
They
Huh?
don't want to bankrupt the town.
You don't want to bankrupt the town. But how come a private party, or even a public party, gets to do something on their land that, where's the language? It says a nuisance, this is on 47 here, that says here, a nuisance has been defined as anything which annoys or disturbs the free use of one's property or which renders its ordinary use of physical occupation uncomfortable. That's Caldwell versus Knox, it cites. Knox Concrete, another concrete case. It was said that a nuisance, and then City of Nashville, it was said that a nuisance extends to everything that endangers life or health, gives offense to the senses, violates the laws of decency, or obstructs the reasonable and comfortable use of property.
See, I don't know why they didn't make the argument that it's their excrement that's smelling. You know what I mean?
It's
not the town's. I mean, that's the people that are suing, I mean, try.
Jack up their sewer rates, everybody's gonna pay for it.
Well, I mean, it's
Well,
their.
but that's the thing. At the end of the day, the cost will be shared. It's not necessarily going to be. But how are you possibly going to differentiate?
Well, I'm just saying, it's, you know what, I mean, I don't think it's silly of an argument, I would just say it's their, they're using the toilets, they're using the system.
Right, but it's the other 10,000 users who are likely creating the bulk of the problem, right?
Yeah.
But your argument, though, is just fashioned slightly differently. We all need sewage treatment facilities, and so we all take advantage of them. They couldn't exist without them. That gets back to almost the cement argument, the social utility of it. The social utility of sewage treatment may even be greater than concrete on a regular basis. What would you do? Would you seek to have those pits covered, even though the cost is significant, at least as the town sees it, for the relative modest interference with the use of the property. Or it's not an interference if you live near it.
Like you said, though, it might come back to bite you in the ass because you're going to pay for it.
Well, you could actually pay for it in more than one way. The case doesn't talk about this, but one is higher rates. There is another argument, and we saw it, it was advanced in Del Webb, is that, well, you may still be able to sue and enjoin them and get them to move, but you may have to pay the cost or share in the cost of whatever that relocation is or the reduction is. And so, again, equitable courts have the ability to balance the remedy in the case. And there may be times that not only will you pay through higher fees, you may be, part of the order could be require you to contribute to the reduction. The sewerage lagoon in this case was, in fact, as the court said, was a nuisance in fact. And then it goes on to say, a nuisance which can be corrected by the expenditure of labor or money is a temporary nuisance, right? So one that's fixable is a temporary nuisance. One that isn't is going to be permanent. Where the nuisance is temporary, damages to property affected by the nuisance are recurrent and may be recovered from time to time until the nuisance is abated. What that means is that every new day of the violation, if it's temporary, is a new injury. And so those suits could go on forever and ever, with the plaintiffs continuing to recover for the 3-year period that would precede, in mass, the 3 years in mass, which would precede the filing of the suit. So they could get damages for the past because it's abatable, and the future would be by some form of injunction. How would you show that? Because it says the measure of such damages is the injury to the value of the use and enjoyment of the property, which may be measured to a large extent by the rental value of the property and the extent the rental value was diminished. How do you show that, whether it's the sewage treatment plant, whether it's the chocolate factory when I was little, whether it's the coffee roasters near me now? I mean, is that unreasonable to say that I don't like the smell of coffee roasting in the morning? I mean, is that a nuisance or not? It's still unreasonable. What's unreasonable? My position or the smell?
I just want the smell of coffee in the morning. Not liking that.
You don't like that, or not liking it is unreasonable.
Yeah.
Well, but to each their own, no?
In this case, no.
No, in this case, no, because everyone, you need a good cup of coffee in the morning. Not that I actually like the smell, and sometimes it smells like toast too. So, toast or coffee, how could you go wrong in the morning, right? But I will bet there are people that say, I hate, I don't want to smell that. Because it seems to carry for quite a distance as well. That's an interference that we could seek to have them do something else? Roast from midnight to 5, don't roast during the morning, don't roast during the day.
So you can be up all night?
No, hopefully not. But that's right. Someone's going. If you're going to complain, you're going to say, I want to be able to open my windows when I sleep. Whatever it is. How are you going to show the diminution in value?
Rental, like, if someone doesn't want to rent it.
So you're going to have to. Well, but someone will rent it. Right? People need to live. People are going to live somewhere at the right price.
That's right. That's why I live in East Boston.
Huh?
That's why I live in East Boston. It's cheaper.
Why is it cheaper? What?
I'm right next to the airport.
Right next to the airport, right? And it is cheaper because of that noise in the airport?
Yep.
So I can't even hear those planes.
Where do you live?
No, just kidding.
Oh, because,
Significantly cheaper.
seriously?
Oh yeah.
Because of the noise?
$100 a month cheaper.
And is it really noisy?
No.
Oh, it's not?
Depends on the weather.
But you get used to it, no?
Yeah.
Because that's the other thing is, when I lived in Dorchester, we were in the flight path. And at some point, you don't hear them anymore, although you do. We were at a party at graduation in winter, right on the harbor. And my God, you couldn't even have a conversation
I used to work on Black Falcon. It's like if you're outside, it's just like, you know, you're talking, it's like,
Yeah, really, it was June graduation, we were having a party, one of our classmates lived there, and you couldn't even finish the sentence outside because it was so loud.
I like those types of parties.
But so is it just we're gonna show the reflection in rental value from a 3-bedroom home near the sewage treatment plant, 3-bedroom home located in the same town, 3 miles away where you wouldn't be affected? That's the difference in value?
Well, and by ordinance, my landlord has to have particular windows in our building, and I should ask him to see if he had to finance that completely on his own?
No, he did not. We have a friend actually that works for the FAA, and what her job is noise abatement like that. And no, there's a lot of that came through the federal government and funding, and actually not just funding, but contractors then to assist them with it. So most of
They're
the
not normal windows.
No, right, no,
They're
and the
heavy.
walls probably aren't
Yeah.
either, because of the extensive extensive attempt to abate the noise to make it more habitable.
it's like where Elwood Blues lives.
Yeah.
Blues Brothers.
Oh, okay, but so tell me how you're going to show the diminution in value, because I'm thinking in part, when you bought that house near the sewage treatment plant, you probably got a reflection in reduction of market value. When the person that came into my office in Boston bought next to the largest auto body place in Boston, my guess is you didn't quite pay top dollar for it because it was reflected in the surrounding neighborhood, which is commercial in part and residential in part, and has had those types of issues for decades. So what is your loss?
That's what I don't understand. You
Right.
took advantage, and now you want it stopped for why you got a price reduction. I mean, that seems to me to be go shit in the hat, you know?
Go ahead, Matt.
Maybe you have some health problems like can't sleep or asthma or any number of other things.
Well, in fairness, I agree. I don't agree. I agree with most of Jim's point. But in fairness to her, this was not. This I think it was starting to generate health problems, and at the minimum, psychologically, the thought of this was becoming all-consuming as to how damaging it could be for her children. So there were health issues associated with it, even if it in part was psychological. Except we also know, because she had it tested, there were paint particles, without a doubt, entering her yard, which if you've got little kids, you would start to worry that what's the effect of that. And that was probably about 20-something years ago, so I don't even know what the component of the paint would have been.
You could probably get an expert to talk about how potentially harmful it is.
Well, yeah, and it wouldn't take a lot to find a reasonable expert which would say, you know, inhaling paint on a regular basis is not going to, you know, you're going to end up like some of those other kids in the neighborhood if you do that. So tell me about the last point about how you're going to show the reduction, the loss, because he says, and I think correctly in part, you paid less already because of where it was located. You bought next to the prison. You should expect those sirens are going to go off occasionally, and you've got issues there. You buy next to the auto body place. Geez, you can smell it when you park your car. You should have expected this.
Would it be like an increase in that smell after a few years, like they're saying this lagoon, the first 3 years, if there was no real smell, and then all of a sudden there was a layer of scum, and that had to be broken down through more enzymes, and that wasn't working, so then they had to put that poor man in the boat. You know, is it over a period of time that the auto body shop grew so more?
Not in my auto body example. That honestly, and this was a little troubling, except she had a legitimate case. That problem had gone on seriously for decades. That's what it was. Is you'd see them sometimes outside, they're spraying out in the yard, out in the then you knew they weren't supposed to do it, and they knew they weren't supposed to do it, but they'd spray out there, so it's gonna go wherever it's gonna go. But that problem had existed for ages, and it wasn't, I've represented clients where they really didn't know that, you know, half a block away was this plant that was going to be doing X, Y, or Z. They really didn't know. She knew. You couldn't help but know. The auto body place was this, and almost on 3 sides of that U were residential homes. On this side were small businesses. But you would have had to know. It's just impossible not to know. It was of that size. But here, you're right. Sometimes the nuisance will grow. The interference will grow. And I don't think we have the same argument, except I heard a lot of times when I gave you the farm case, many of you were saying, well, what were you thinking of? It's called the Village of Dooney Farms. You had to know that there'd be farms back there, and the farm was there, and that the likelihood is the farm would smell. I'm not sure people from the city do know that, though, you know. I really didn't know. I thought there'd be nice smells. I didn't think it would be, I really didn't.
No, I moved to New Hampshire thinking it was going to be a fairy tale type of thing, and there's a distinct smell of New Hampshire too. Then I go, oh God, I'm
Maple
home.
syrup?
No, it's not maple
It's not
syrup.
maple syrup.
Well, but it is, and that's the other part of it, though. It's part of what you get used to. So the nuisance is subjective or objective? It is objective. Well, you were telling me the coffee's not going to fly, or is it? The chocolate.
Well, I said everybody should love it.
But they won't be. It won't be. I've had people say they don't want people to make popcorn in the machines downstairs because the smell somehow.
Gets them hungry?
No, affects them physically. There's some. I don't.
There's everything is gonna aggravate somebody. You know, I mean, there's nothing that everybody likes. So there has to be a point where you could, come on, you know.
So it is objectively. It's got to be an objective standpoint that it's a nuisance.
I think it's both.
It's both. It can be subjective or objective. It can't be personal. But subjective is personal, isn't it? Your own feeling.
Yeah.
But it does talk about unreasonable. But this one said, a nuisance has been defined as anything which annoys or disturbs the free use of one's property or which renders its ordinary use of physical occupation uncomfortable. The next case in that sequence goes on to set a little higher standard. Everything that endangers life or health but then it says, gives offense to the senses or obstructs the reasonable and comfortable use of the property.
Wasn't there a case about a shadow or something? I don't believe.
Oh, sure. Shadows you could argue and have been argued. The shadows and the light, the access to light, some of those are real more view cases, but again, you've got to fashion something that the law is going to recognize. So how are you going to show the diminution in value? Because this is part of what you get to sue for, is you can sue for the past injury within the statute of limitations period, and then seek to enjoin it in the future. So so tell me what your evidence is. Is it this says here you're going to have to show the diminution in market value. So whether it's
it develops in the home equity and people will try to buy it or offering you less than what you paid for it, and you have no means of renting it because of where it is.
so wait a minute though. So you're seeking a permanent award, or you're seeking an award for the past loss of use, in essence, on a monthly basis for that property? Because if it's temporary, if it's abatable, then you've got a 3-year period in which you can recover. You get an injunction to prohibit the future use of it, and so your damages won't extend. But obviously, depending on the social utility, you may have some ongoing problem that may result in a permanent award of damages as well. So market value approach, rental value of a similar home further away from this nuisance is $200 more a month. So in essence, I've lost $200 a month because I'm paying more than I should be paying in this property. but you're gonna have to show that, right? What if your rent already reflects that? What if the purchase already reflects where you are located, which to some extent it's likely to, isn't it? You bought next to the sewage treatment plant. A lot of people wouldn't want to live there. You paid $20,000 less. You haven't lost anything. He says you got a good deal, and you got a good deal because of the problem you're now complaining about.
Yeah, but I mean, the prices of houses go up, so if you paid $50,000 for it, 40 years ago, now you're losing, let's say the guy, what I mean, you've got a deal of $20,000, but now you're losing, $150,000 or something more.
But again, that's at least in part reflected in what the value you originally received. Somehow, if you want damages, you're going to have to show me the reduction in market value. Maybe that's what it is.
I think this one, you can get a public nuisance, which is much more effective, because that smell obviously isn't just your house.
Well, tell me what the public nuisance would do that the private won't, would you expect?
The town's more likely, because this is such an easy fix for them.
But why is it such an easy fix? It's still, if it's going to be cover the lagoons, it's $10 million. It's just that there's likely a lot more people affected.
They can just chum the water.
Oh, okay. You mean what Pate versus City of Martin did? Are there other less costly alternatives that will reduce the nuisance? Right? I mean, because that's what they did here, is they fashioned the remedy, as was pointed out. It hadn't always been this bad. It had been allowed to sort of fall into disrepair, and there were methods, relatively inexpensive methods they could take. They put the little tiny bowl guy out in the speedboat and had him run around to churn the waters, and that did a remarkably good job of significantly reducing the odors. So that's your order. That's your injunction.
What if the city did some kind of eminent domain and just say, you know what, it's cheaper to take this house and pay your market value as opposed to spend $10 million and fix this?
Well, could they?
Just bar anyone from living near there.
Could they?
Why not?
Why not? Right? They could take the property by way of eminent domain and pay market value for it. That's what's happened near a lot of the airports. Depending on how close you were, there's no way to abate some of that. And it might be easier to simply take the property and condemn it. In essence, we're going to take it by eminent domain. And some of the land, some of the property may well be easier than having to litigate it forever. That's an alternative for the town to look at. Problem is, we're still now talking about the expenditure of at least a significant amount of money for some period of time. You know what was interesting? When Gillette's plant in South Boston, and they were converting a lot of the surrounding area to condominiums, expensive condominiums, they put right into the master deed and the condominium documents that this is a commercial area with trucks coming and going at all various hours of the night, significant trucks and significant commercial manufacturing activity that you are buying subject to all of these problems and should be aware of it, and you are waiving any rights to have call that a nuisance or seek redress for it. So there are ways in which you sort of can plan around it, and they did that at the condominiums where Gillette, the razor company, is located in South Boston, as that neighborhood started to some extent convert to more expensive condominiums than just simply manufacturing. And there are ways in which we could write it into the deed. Take the property, condemn it, take it, put this restriction in the deed so that it's going to carry with the land. Then at that point, maybe the town could resell it under those circumstances to someone who recognizes they're buying subject to that. The same type of thing happens when there's been a permanent award of damages against the land. Right? If we're going to say it's not fixable, and they will make a permanent award because of the social utility of that function that the defendant does, and there'll be a permanent award of damages, the likelihood is that judgment will be filed at the Registry of Deeds, so that whoever takes then subsequent to that action is taking, and the likelihood is taking without any recourse to seek further remedies whatsoever with respect to the nuisance that they now are likely to experience because they're taking with knowledge of it and there's been a permanent award. Again, the temporary nuisance, and this is what Pate versus City of Mountain talks about, the temporary nuisance can be corrected, and this one, they fashion relief that is relatively easy to correct, and in fact, I think kind of clever for relatively short money. Twice daily he runs the motorboat, and that significantly reduces the problem. Equity can be creative, and equity can fashion relief as it sees fit. And I think it's an interesting example of relatively modest expense to be able to hopefully reduce it significantly. Our town never covered the lagoons, but they did take some steps to try and alleviate some of that problem. I will guarantee you within the next month and a half, as I'm driving up there with the top down, I will smell it. Go ahead.
Could you also ask the court to have them do it, like divert it and have another lagoon, just to?
But where though? So now it's next to Matt's house? I mean, this is the problem, is same type of thing with the concrete plant, same type of thing with a lot of these things as you think about them. They've got to be somewhere. They've got to be somewhere. So who wants to be next to it? And the problem is, we used to see it just out here where you've got these big developments. Now we see more and more people moving back to the city, and the city has a lot of this similar issues with respect to manufacturing and businesses located in residential parts of it. Listen, some people don't want to be right next to the bakery, right? Bakery probably comes on, starts work at about 2 or 3 a.m. All sorts of smells, and if it's not the ovens and that noise you're listening to cooling agents. Next to again, these problems are everywhere. Next to us is this Butcher Boy Plaza, which is this really nice commercial development. Like they print money there. You might as well print money. But what they've been so successful, they needed to add on to the building, but they didn't do it permanently. What they've got are they sell meat. They've got these 2 temporary refrigeration units that are on the very back end of the property, like the sheds. You put them as far away so you don't have to listen to the noise. The problem is that they're going virtually 24/7, and the next door neighbor is saying, "What the hell?" It's not a permanent facility, and it wouldn't comply permanently because it's too close to the lot line. B, this noise is rendering my it's an expensive house. It's on Great Pond Road. He lives across from the lake. Saying, why do I have to listen to this? So that just simply because they can make more money. And so they're complaining now that it doesn't comply with zoning, which, by the way, for nuisances and the like, and the first place you start your investigation is with the Board of Health and zoning, right? If you've got Board of Health issues or zoning, it obviously helps to create and support your argument that, in fact, it's a nuisance, because part of those regulations are designed to protect the public health, safety, and welfare and the like. And conversely, to the extent they do comply with zoning and health, then they've got a better argument that they're doing what's lawfully permitted on their land, and so it weakens your case. A lot of times you may ask them to investigate, or perhaps even make a complaint so they have to investigate, but a lot of towns don't have the resources necessarily. Certainly the resources of a private litigant who is interested in seeing a quicker resolution has. But that's a solid place to start and look. That's the other part, to try and see to what extent it may be public as opposed to private. Are there other complaints? Have other people shared the same problems and voiced concerns, so that to the extent that we can garner more support, there is a greater likelihood that the town will take a more active role in it, to the extent it affects more than a few people. At the end of the day, you have the right to go in and seek recourse. And again, you're going to try and figure out whether it's temporary or permanent, and then you're going to try and figure out to what extent you have the right to seek the recourse. But as we can see from these cases, the court has a significant amount of leeway in fashioning the appropriate relief, and there will be times where you won't be able to get the injunction. There will also be times potentially where you may be asked to share in the cost of reducing whatever the nuisance is, and that can get expensive. The problem is when we look at some of these that have a significant social utility, where else can they go? As he points out, we need concrete, we need sewage treatment plant, we need prisons, we need a lot of things. No one wants to be right next door to them with the attendant problems that come with them. But the fact is, someone's going to live closer to them than others. And there's a million different things that affect people that on a regular basis, it may seem interesting occasionally to be exposed to it. If it's 24/7, you will have litigation at some point. Let's talk about Myers versus Arnold, which is the last case in our sequence here. The case involves 60 to 80 truckloads of concrete, all dumped on plaintiff's property. A jury found that dumping was wrongful, gave them a verdict of 12 grand. And the defendant says the trial court erred when it allowed plaintiffs to recover the cost of repair rather than the diminution in market value. This is all of this concrete and iron bars and the like were dumped on 1 acre of their land, and it says 50 by 150 feet. The concrete contained reinforcing rods, was stacked 8 feet high in some places, covered an area approximately 50 by 150 feet, 7,500 square feet. It had been placed where the plaintiffs intended to build a second house. That's what they say now. Mrs. Myers immediately contacted Howard Arnold, but he would not agree to remove the concrete. She wanted some fill, and instead of fill, a couple of loads of concrete. She ended up getting 60 to 80 truckloads. Removing the concrete, the total expense would be $18,200. And if you were able to find someone closer, it would be less. The value of an acre of land was $650. In '74, plaintiff's property would have been worth $650 per acre. And this was the appraiser testified the date of the trial. Fair market value was $750. On the date of the problem, it would have been $650. And they're arguing about what the measure of damages is in this case. Defendants feel that the plaintiff is getting a windfall because the plaintiff wants the value of the removing the concrete which $12,000 representing the cost of repair far exceeds the diminution in the market value of her property. If the value of a lot is $750, give her $750, she doesn't get the 12. What is the plaintiff entitled to get here? And is it dependent, is it at least partly dependent because she intended to build a second home there? Is this, we going back to a person's home is their castle, and that she gets the 12 grand because the 12 grand represents the cost to restore the land to what it was, and now she can build a house? Because I'm kind of skeptical that if she's got 24 acres here, that when she gets this 12 grand, she's going to build right on that house, right on that spot, as opposed to one of the other acres and pocket the 12 grand. Because I get a bunch of loads of dirt, cover whatever is there, and build somewhere else and pocket probably 10 grand. I think most of us would, wouldn't we? But she gets the cost to repair, even though, let's be honest, who in their right mind would do that under these circumstances? Unless it's the lot overlooking the ocean, and I would think if that's the case, the decision would have said it. She's got 24 acres. She's just got to move it a couple acres away, and she's pocketing 10 plus grand.
That's the average your land, Bill.
Huh?
Bill, what you want on your land, that's the argument.
So if it's her land,
Most defensible position, right there.
and it's a temporary nuisance, she gets to get her land, or at least the value of her land, restored to what it was. Right? If this had been someone who was just holding the land for commercial purposes, would it be simply the value of an acre? Or would they also have the ability to have the cost to repair, since this is a temporary nuisance, right? It's not permanent. Is that right?
Yeah. Yes.
Again, temporary being because we can fix it. It says, the rule which the court adopted requires a determination of whether the injury is permanent or non-permanent. If permanent, the measure of damages is the market value of the realty before the injury, less its market value after the injury. When the injury is non-permanent, the measure of damages is the cost of restoring the property. Simple as that. So what she's entitled to, since it's temporary, is the cost to repair. But if it was permanent, then at that point, all it would be with the diminution in value, which is $750. Defendant says the diminution rule makes sense because you're not going to have economic waste. She shouldn't get the cost to fix because that greatly exceeds the actual value of the land. We don't care what the defendant thinks? Because we're going to follow the rule. Temporary means cost to fix, and this is absolutely temporary, even though we've got values of somewhere between $12,000 and $18,000 to restore the land. So what do you think about the economic waste here? Who cares? There's plenty of money to be made doing these roads. So the plaintiff gets a windfall of 12, or it's really not a windfall because there is an actual basis for it. She says that's the cost of repair. And that's what she's entitled to get. Once she gets the money, there's no control over whether she actually repairs it, though. Who cares? The rule's nice and clean. Cost to repair, when it's temporary, is what she gets. Does it make a difference whether she intended to build her home there, or even if she was a commercial, a person who owned the land for commercial purposes? Would still be the cost of repair? Because do they make that distinction? Or is it simply no, the distinction here is temporary versus permanent?
They talk about that.
Temporary versus
Say,
permanent.
go ahead, what?
They do talk about that in their reasoning a little bit.
With that this is her home. And this is where she intended to build a home. And therefore, you can't just look at an acre as worth the same as any other, because it does say, allowing the plaintiff to recover, this is on page 321, the lesser of the cost of repair or the diminution in market value may be appropriate where the interest which has been harmed is purely financial, as where the land was purchased as a business investment with an eye towards speculation, or where it is held solely for the production of income. However, the same measure of damages may be painfully inadequate when the land is held for a personal use, such as a family residence, and the harm may be corrected with a reasonable expenditure, even though the expenditure exceeds the amount of the land has diminished in value. In the latter case, the full repair cost will come much closer to restoring what was actually lost and will not require the injured party to correct the harm with funds from his own pocket. So if it was commercial, we could have a different measure of damages here. So would you tell your client what the difference is? Because the difference here is quite significant. Was it 10, 75, another $5,000, about 15 times difference is the difference in why she was holding that property. Could you explain that to them? Is that where you wanted to build your house? Because if that's where you wanted to build your house, you are likely to be able to recover much more money than if it would somewhere else. That's your testimony? Is that your advice?
I'd explain it to them in some way.
I'll explain it just like that.
Are you worried at all that you're encouraging them to sort of fudge what might have been the facts, or you're just simply advising them as to what their legal rights in the law is based on what they would want to do?
It's telling them what it is. If that's what your house wanted, if that's what you wanted it, this is what you're gonna get. If you didn't, you're not gonna get as much, so you tell me what you wanna do.
And it's not quite unfair. I mean, it's not the true commercial transaction no matter what, because they did have another home on the land. They did intend to build, at least they say, they intended to build another home on the land. The only question is, in that exact spot? Because I'm a little dubious, but the fact is that, we're reading the case. The jury heard the evidence. The jury listened to the plaintiff. They believed that the plaintiff's story was in fact correct, both with respect to what she asked for and what the defendant ended up delivering being completely inconsistent with what she was looking for. And there is a strong argument as to why should the plaintiff bear any of that loss then at that point, and perhaps even obtain a windfall on the cost of repair, even if they don't ultimately repair it, because the law is pretty consistent with respect to the difference between temporary and permanent. That's the easy part. The only question then would be if you accept that that's where they were going to build a house, but the jury determined that that is in fact credible, that that's the spot where they intended to do it. And I think, and also in part, the jury had to find that the defendant wasn't credible, because the defendant was saying, oh no, that she asked for a lot more than 1 or 2 truckloads, but the jury didn't accept that portion at all. And he said, if you had asked for 2, I wouldn't have done 2. And the jury didn't accept that version of the events either. Next week, we've got our last 2 sections, so you've got to do both 14 and 15, 14 for Tuesday, 15 for Thursday. And then we're done. Questions? I'll see you next week.